We're going to talk about secondary victim claims, and particularly whether things are any clearer. The reason why I have titled the talk in that way is that some of you may be aware of the most recent case of Paul and Royal Wolverhampton NHS Trust, a decision of Mr. Justice Chamberlain in the High Court that has clarified some aspects of what are commonly known as the control mechanisms or gateway criteria that have caused so much consternation amongst practitioners. So this talk is going to start with a very brief bit of history as relates to nervous shock, psychiatric injury, secondary victim claims. We're going to explore the control mechanisms, gateway criteria, whatever you would like to term them. That is going to involve some analysis of the decision in Paul. And hopefully, as I say, there will be enough time for a question and answer session at the end. I see that it's in the comments section. I appear to be breaking up. If that is the case with anyone else, please do let me know, because it might be a problem at my end. What we will not do is cover every case in detail, purely for reasons of time and purely for reasons of trying to keep things as straightforward as possible. The law of secondary victims is an area of law that I think has perhaps been overcomplicated, not through any intention, but because in all of the appellate authorities, there are sometimes at least several different judgments iterating similar principles, albeit with different wording, which can sometimes cause confusion amongst lawyers who generally look for certainty. So please forgive me if I do rush through some of the details in the cases themselves. Right, so let's start with a plotted history. And hopefully this will allow you just to grasp quite how long this saga has been going on. So we know that nervous shock claims, as they were then termed, were being brought in the mid-19th century. That was Lynch and Knight as early as long ago as 1861. That was an unsuccessful claim brought in the mid-19th century. They began to be successfully brought around the turn of the 20th century. That's Dulieu and White and Sons in 1901, but with the provision that the fear of injury to the victim had to be to the person themselves, to the individual, rather than to another person. There was then also a loosening of that restriction 25 or so years later in Hambrook and Stokes, and later in Boardman and Sanderson. In the first case, a mother's shock arose from the sight of the event herself, the fear of her children's safety being involved, I think, in is either a road traffic accident or a train crash. And then Boardman and Sanderson loosened the restrictions further, introducing the immediate aftermath test that we perhaps are familiar with today. So a potted history, you can see how long this train has been running. For our purposes, as we understand it and apply the law today, the modern beginnings of secondary victim law begin in McLoughlin and O'Brien, House of Lords case in 1983. Briefly, the facts of that case were that the claimant's husband and children had been involved in a road traffic accident. One child was killed, and the husband and the two other children were severely injured. The claimant didn't witness the accident directly, but it was reported to her some 2 hours later. And at hospital, she saw the extent of the injuries to her husband and children and heard of the death of her daughter. And as a result of that, she suffered severe and persisting nervous shock. Those were the facts of the case. the lead judgment fell to Lord Wilberforce, although there are several other judgments of note which we won't be touching upon in the case. Lord Wilberforce summed up the jurisprudence up until that point as follows. Firstly, that a claim for nervous shock rather than grief or sorrow could be made without showing direct impact or fear of immediate personal injuries for oneself. So that was Hambrook and Boardman. Such a claim could be brought on by injury caused to a near relative or by the fear of such injury. Now, at that point, whilst we're familiar with love and affection as the test, the cases by this point didn't extend beyond the spouse or children of the claimant. A claimant wasn't able to recover damages where the injury to the near relative occurred out of sight and earshot of the plaintiff unless they had come upon its immediate aftermath. And fourthly, whilst bystanders who came upon a serious accident involving numerous people could not recover, a rescuer could. And that was the case of Chadwick, that some of you may recall, at least from law school. Well, what were the courts to do about Miss McLoughlin? As has characterised the progression of this area of law, the courts would proceed in the traditional manner of the common law from case to case upon a basis of logical necessity. Well, the logical necessity that allowed Miss McLoughlin to recover was as follows. Although her claim was on the margin of what may or may not be recovered, it was hard to see, Lord Wilberforce said, that why she should not succeed when, if from a distance of 100 yards she had found her family by the roadside, she would have been included. He went on to say, and his lordships agreed, could it make any difference that she comes upon them in an ambulance or a nearby hospital where they were in the same condition, covered in oil, mud, and distraught with pain? So if Mr. Chadwick could recover when acting in accordance of normal and irresistible human instinct, i.e. as a rescuer, why could a mother not claim when it was similarly foreseeable and acting under the same motives she were to go to where her family were found? So it seemed that the courts were moving in an incremental step-by-step approach. However, words of caution were sounded from the Lord Wilberforce and his lordships. Several concerns were raised by the defendants, the floodgate arguments, which had its a ring of truth to them. So these were, as articulated by the defendant, a concern that there might be a proliferation of claims, possibly fraudulent, along with the establishment of an industry of lawyers and psychiatrists who will formulate those claims. A simple floodgates argument. An extension would be unfair to defendants, it was said, as it would impose damages out of proportion to the negligent conduct complained of. An extension beyond the most obvious cases would greatly increase evidential difficulties and lengthen litigation, a sort of precursor perhaps of proportionality as we're familiar with it today. And fourthly, and I think most importantly, as far as policy reasons go, such a radical extension ought only be made by the legislature. That last concern is something that has echoed throughout the subsequent cases and has found claimants wanting. Therefore, whilst Lord Wilberforce was clear that some of those concerns might be overstated, there was a need to introduce what are known as control mechanisms. These weren't dreamed up on the spot. These were, if you read the judgment, essentially distilled from the long line of case law that followed before McLoughlin. And they'll sound particularly familiar perhaps to you. So the first was the injury reasonably foreseeable? I.e., would a person of customary phlegm or normal fortitude suffer psychiatric injury? Secondly, there had to be a close, and what was in McLoughlin, most close, most likely family tie. There had to be proximity, both in time and space, to the event, which would include the immediate aftermath. And there had to be shock through sight or hearing of the event or its immediate aftermath. So that was the start of what has become familiarly known as the Alcock control mechanisms. I don't think I need to recite the facts of the case. They hopefully will be well known, at least partly, to most of you, but the case arose out of the Hillsborough disaster and the psychiatric suffering that many endured as a result of witnessing that disaster and its consequences in 1989. The judgment is a long one, and again, it's much like McLoughlin, one where several of their lordships seem to give similar but different formulations of the tests that need to be applied. However, it essentially comes down to this: reasonable foreseeability, so no change there, a close tie of love and affection to the immediate victim, not necessarily a family member, closeness in time and space to the event or its immediate aftermath, and that the nervous shock must have come through the claimant's own unaided senses, i.e. as a consequence of the sudden appreciation by sight or sound of a horrifying event. So what we are going to do is we're going to explore each of those. We're going to gloss over reasonable foreseeability, because hopefully that doesn't need much explanation, and what needs to be examined are the remaining criteria. So let's start with ties of love and affection, relatively straightforward. Firstly, it's a matter of proof for the claimant, often forgotten, and it's often forgotten because it is presumed in the case of a spouse, parent or child, and possibly fiance. I say possibly fiance, that was in Alcock. I have no doubt if the same case were to come before the courts today, a fiance would qualify. It has to be at least the relationship comparable in terms of the care received given that you would get from one of those family members, but it does not always have to be a family member. So there's one case on the slides there, hopefully you'll be able to see, McCarthy and Chief Constable of South Yorkshire. The facts are really not particularly relevant for today's talk, but damages were awarded to the claimant's half-brother. The claimant was the half-brother of the primary victim, and they lived separately in different accommodation. However, firstly, the fact that they lived separately wasn't of significance, since it wasn't unusual at the time for families in Liverpool to send children to live with grandparents when their house was overcrowded. But also, on a close examination of the facts of the relationship, it was found comparable to that of a spouse, parent or child. So that is the first point that you need to remember. It's a matter of proof, it is presumed, but it is not necessarily restricted to a family member. Proximity to the event or its immediate aftermath. Now, this is perhaps the area that has caused the most difficulty. And in preparing this talk, it occurred to me, or at least my thoughts are, that the reason it causes difficulty is because the gateway criteria essentially overlap to some extent. So it's difficult to separate each hurdle from one another, but I'll try to do so. So this gateway criteria control mechanism, it should in fact be broken down effectively into four. First of all, you've got to ask yourself, what is the event? Or rather, do I have a qualifying event? Secondly, did the claimant come upon that event's immediate aftermath? Thirdly and fourthly, which is the third or fourth control mechanism, is the event sudden and is it shocking and horrifying enough? So we'll go through those in turn. And the way we're going to do that is I've picked out some of the most relevant cases, none of which really lay down a definition, or not at least until Paul, but they give you a flavour of what was considered not to be an event rather than what would be an event. So the first of those cases is Taylor and Somerset Health Authority. It was a case in 1993. The brief facts of that case were that the claimant's husband suffered a heart attack whilst at work. The heart attack was a result of the negligence of the defendant health authority to diagnose his disease, heart disease. He died at work at about 3 o'clock in the afternoon. The claimant was informed that her husband had become ill and was at hospital within 20 minutes. 20 minutes after that, she was informed that he had died. So, not believing it, she identified him within the mortuary a few minutes later. So what was the court to make of that? Was there an event? Well, the claim was rejected by Mr. Justice Auld. And in doing so, he opined or held that you had to effectively go through this twofold test. It had to be an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death, and perception by the plaintiff of the event as it happens, normally by his presence at the scene or exposure to the scene, and or to the primary victim so shortly afterwards that the shock of the event, as well as of its consequences, are brought home to him. In this particular case, there was no such event here other than the final consequence of the progressively deteriorating heart condition, which was the key in the case, which the health authority by its negligence had failed to arrest. And so in this case, the death at work and the transference of the body to the hospital did not constitute an event. The claim was also dismissed because the communication of death by the doctor would not qualify, and that was established in McLoughlin. We'll come on to that at the end. Next, you have Walters. It's quite an infamous case in this sort of area of jurisprudence, 2002 Court of Appeal case. Very tragic, in fact. The defendant failed to diagnose the child's hepatitis. And what had happened was that she had returned to hospital a week later, I think, and was in the hospital room with her child. She woke up to her child, who was rigid, coughing blood, fitting, and effectively from then over the next 36 hours was much of the same until the child died in the mother's arms. It was obviously an extremely traumatic event for the mother, and the court had a degree of sympathy for her claim. So in relation to what is an event, the court held an event was not a single moment frozen in time, and in this case there was an inexorable progression, a seamless tale, and a drawn-out experience from the failure to diagnose to the fit to the brain damage, which made the termination of the child's life inevitable. It had been a drawn-out experience for the claimant that would qualify for the purposes of recovering damages. We then move on to Taylor and Enovo UK Limited, a 2013 Court of Appeal case. The facts of that case were that the claimant's mother was injured whilst at work as a result of a workplace accident, negligent workplace accident. She injured herself, but she was recovering well when 3 weeks later she unexpectedly collapsed and died, and she had suffered DVT and then a pulmonary embolism, and the claimant witnessed the actual death of her mother and suffered PTSD. However, the claim was rejected. The Court of Appeal held that the defendant's negligence had two consequences separated by 3 weeks in time. So you had the accident and the injury, and then the pulmonary embolism at the end. So there wasn't a single accident or event in which the claimant could hang her hat. Furthermore, the death was not the event. Lord Dyson drew a comparison with the claim where, to say, if the claimant arrived at work, she probably, although might, but probably would not be able to recover damages. So in that event, why should she be able to recover now? And secondly, the court was simply of the view that the leap being contended for was far too substantial for the courts to allow. Walters, which was the case we had just looked at, was distinguished on the basis that it was a seamless tale of as one event rather than two separate ones. So that's how the court got around that. We then finally, before we come on to Paul, have Liverpool and Women's Hospital NHS Foundation Trust and Renane. That was a case where the claimant's wife underwent a negligent hysterectomy, and after being discharged became unwell. She deteriorated rapidly over 24 hours in hospital, and the claimant suffered a psychiatric injury from seeing his wife in that condition. Again, not a seamless tale. It was a series of events, but for the purposes of Paul, and I think which has been glossed over, it was accepted in that case that the event was the point at which the negligence became actionable. And we'll see why that's relevant in a moment. So we'll come on to Paul, which provides the answer to the question, what is an event? It was a case where, for those of you who haven't read it yet, the claimants were out walking with their father. He mentioned he felt ill, his eyes rolled back, and essentially he had a heart attack and hit his head on the floor. Attempts were made to call 999, and although paramedics did arrive, there was a traumatic scene that the claimants had witnessed, and the father died 20 or so minutes later in hospital. The reason for the father's collapse was a failure to diagnose a heart condition in 2012, so some 8 years before at least this appeal was brought. And so there was clearly a long time between breach and the injury complained of. Although the claim was struck out by Master Cook, it was reinstated by Mr. Justice Chamberlain. The defendant's submissions as to why it should be struck out was that, firstly, the event had to be synchronous or approximately synchronous with the negligence. So that would be in 2012. It also had to involve a positive act rather than an admission, and the event had to be external to the primary victim. All three of those were rejected. 1 and 2 were effectively abandoned upon appeal by counsel. But number 3, as to the external event, was what the defendant held their hat on in relation to the definition of event. So in Somerset, the Taylor and Somerset case, the quote was, an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death. The defendant was arguing an external event was necessary, but Justice Chamberlain was of the view that it was a reference to injury external to the secondary victim, i.e. it was not something being done essentially to the primary victim. So that's how that one was gotten around. In short, Paul arrives at a definition somewhere around these terms. The event that will qualify is the point at which the tort becomes actionable, i.e. when damage is actually caused to the primary victim. When damage is caused is a matter of fact, so you'll need medical evidence to establish if that did not occur, and then it will be argued at trial. So in Paul, the pleaded case, because it was a strikeout application, was that damage occurred at the point of heart attack, and because it was a strikeout application, it had to be taken as read that was when the damage was occur. There was some discussion of, well, if that's not the case, what would happen to the claim? And Mr. Justice Chamberlain did say that such a claim may be precluded by Taylor and Nova. That's the workplace accident with the mother and daughter. In any event, there would be no further events after the damage first became manifest. So if you want an endpoint as to when your event is going to be, you need to see when the damage becomes manifest to another, and that is the endpoint. Your event's got to be at that point or before it. So that is what an event is. So what is an immediate aftermath? For obvious reasons, the court have been extremely reluctant to say or draw any line in the sand as to what will qualify as an immediate aftermath. I say the reasons are obvious because if the court picked a time, it would A, be arbitrary, although a lot of the tests are in this area of jurisprudence, but also it would give rise to complete lack of flexibility. So, for example, if 2 hours was picked and you ended up at 2 hours, 5 minutes, it would seem illogical for the claim to be dismissed automatically. That said, you can probably get a bit of a feel for what would qualify as an immediate aftermath from several cases. The first is Alcock, which we know about, 8 or 9 hours after the accident. That was too long. McLoughlin qualified. That was 2 hours after being informed that the claimant's husband was in the accident. Taylor and Anovo, 3 weeks, too long. And Gale, Atkinson and Siegel, the 2003 Court of Appeal case, was approximately 2 hours also, or at least on my reading of the case report is approximately 2 hours. Briefly, that was a case where a mother's daughter was involved in a road traffic accident. She died at the scene. She was taken to hospital. The mother arrived at the scene of the accident, whereupon she was informed of her daughter's death and she broke down at that stage. She was then taken to the mortuary around an hour later, where she identified the extremely disfigured body of her daughter. And in that case, it was said that the claimant had come upon the immediate aftermath of the death of her daughter. So much like when you value general damages, there's never a precise figure and you've got to look at the case, but perhaps using these cases as comparables might give you a feel of whether the case you are dealing with qualifies as an immediate aftermath. Thirdly, the event itself must be necessarily shocking. And it is here that the bar is set extremely high. So on the screen, you will see some of the quotes that illustrate what will qualify. So in Alcock, it must be an event that violently agitates the mind or be a sudden assault on the nervous system. A case of Shorter and Surrey and Sussex Healthcare Trust, apologies for the typo, stated that it must be exceptional in nature. And you've got to approach that test with a degree of honesty when looking at your case, because it is an objective standard that is judged by persons of ordinary susceptibility. And unfortunately, a lot of events, especially in the clinical negligence setting, will fall at this hurdle. You also have to look at whether the event was sudden enough also. And there are 3 cases which unfortunately are not on the PowerPoint presentation, but they will be on the PowerPoint presentation put on the website, and they'll also be within the notes that I'm going to publish on the website also, that have guided me in putting this talk together. So apologies for that. But your sudden event, there are several, again, cases that might help. So there's one called Taylorson and Shieldness Produce. That's a 1994 case. In that instance, the claimant's son was crushed by a reversing vehicle and was taken to hospital. The claimant was told of the accident soon after it occurred, drove to hospital, and then followed the ambulance and transferred their son to a second hospital. And they caught a brief glimpse of their son, again in a disfigured state, upon transfer to ICU. They stayed with him for 3 days in ICU until his life support machine was shut off. That was not a sudden event. It was a series of events, not shocking enough individually in themselves, and therefore there was no recovery for the claimant. The second of the cases is Sion and Hampstead Health Authority, a 1994 case also, much similar to Taylorson, where the claimant suffered a psychiatric illness as a result of a hospital failing to care for his 23-year-old son who was in an RTA. The claimant in this instance was at his son's bedside for 14 days until he died. But again, there was no single shocking event, no sudden shocking event. And the third case is, I would return to Liverpool and Renane, which was earlier. Some of you might recall. Again, it was not a sudden event. You'll recall that deterioration occurred over 24 hours. It was something, an anxiety that had begun to creep into the claimant and then manifested itself eventually right at the end of the series of events. So it was not sudden enough to qualify as a secondary victim claim. So that is what is meant by sudden and shocking. Finally, I just want to deal briefly with the means of perception of the event, because it will be recalled right at the start of this talk, I drew attention to the fact that what must be witnessed must be through the sight and sound of the event itself, perceived by the claimant. It's long been established since Alcock that TV is not sufficient, or seeing the accident happen through TV was not sufficient in order to perceive the shocking event. That was particularly in the case of the Hillsborough disaster for two reasons. Firstly, in the Hillsborough disaster, there were no recognisable individuals. No claimant could point, as a matter of fact, to saying, I saw my husband or brother or whoever it was on TV, and therefore it was deemed not qualifying enough. And secondly, the trauma arose not from seeing the pictures, but being in the knowledge that a loved one had died. So it wasn't through a perception of an event rather than knowledge of what had happened. That was important. However, what the door was left open to was simultaneous broadcasts. So they were not ruled out by the House of Lords as being equivalent to actual sight and hearing of the event or of its immediate aftermath. Then Alcock Lord Ackner cited the example given by Lord Justice Nolan in the Court of Appeal. So where you had, for example, the televising of a special event in which children were travelling in a hot air balloon. Your child is travelling in a hot air balloon and it suddenly bursts into flames. The impact of that on a parent might be such to be the same as, if not greater than, actually being there. And so the door has been left open for live broadcasting, as long as you can obviously identify that your child is in the balloon or whatever the event is. You also have, finally, the communication through a third party, that your loved one has died. And that has, again, since McLoughlin and Alcock, long been established that was not sufficient in order to establish liability. And so that seems to be a relatively settled point or principle of law. Sometimes it is said that negligently communicating distressing news may be sufficient, and reliance is often placed by claimants on AB and Tameside and Glossop Health Authority. In that case, the facts were that as a consequence of being told by letter through their GP that they had received obstetric treatment from healthcare professionals who were HIV positive, they had suffered psychiatric injury, and it was averred that instead what should have happened was that their GP should have been informed and that they should have had a face-to-face conversation. So what was complained of was the method of communication. The claim was, or the claims, because it was a group action, were dismissed because that would be placing too high a standard on the health authority. However, in relation to the existence of a duty at all, it was admitted by the defendant that a duty lay upon them to make sure that that news was communicated in a way in which it was not foreseeable would cause psychiatric injury. It's just important to note that because it was admitted, it wasn't in dispute, and therefore that point hasn't been tested either at first instance level, but certainly not at appellate level. And so I thought I would just be a bit careful about hanging your hat on that as well. So to recap, before we open up to any questions and answers, the first thing to ask is psychiatric harm to the secondary victim reasonably foreseeable as a result of the breach of duty? If it is, and that is an objective standard, is there a close tie of love and affection between the primary victim and the secondary victim? Something that will be presumed in cases of spouses or children, but may need to be proved nevertheless. Thirdly, you'll need to identify the event where the tort to the primary victim became actionable. When did the damage occur? And at least when did it become manifest? Next question, was the secondary victim either present or at least within that event's immediate aftermath? If they were, then was the event complained of sudden and shocking enough by objective standards? Was it something that violently agitates the mind? And there you have a recap of what you will need to establish a secondary victim claim or to defend a secondary victim claim. Finally, the definition of event has been given, and so hopefully that is some use, at least in a clinical negligence setting. That said, of course, we don't know whether Paul is going to be appealed, so if I were you, we should all watch that space.